But I had a team of 3 prosecutors who are here. In terms of directions, my lady, we are ready to take directions on sentencing. We'd also like time to request and provide to the court reports on previous convictions for the accused persons.
We'd also like
Time, so that you can request from the DCI reports on any previous convictions of the accused persons. So we can supply the same to this court. My lady, we'd also be requesting the court to order for pre-sentence reports from the probation department. And for the same to be supplied before the next sentencing hearing date that you'll grant us. My lady, finally, in regards to the judgment you have given, we'd be requesting that the 3 accused persons' bail bonds be cancelled and for them to be remanded in custody. That is all, my lady.
Mr. Awar.
To emphasize that the request for specific order for preparation and supply of victims' impact. We request for specific order to the probation officers to prepare and supply us with victim impact statements prior to the date that will be set. Prepare and supply us with victim impact statements that the Victim Protection Act, Section 12, them be done prior to the date that the court will set for sentencing. Thank you.
Your Ladyship, I wish to address you on the request for cancellation of bail. That's the only issue I wish to address you on. Your Ladyship, the preparation of the reports from probation officers, including the victim impact report,
The preparation of the
probation, resentencing reports which the prosecution has requested, and the victim impact assessment reports. The preparation of those reports takes time. And so the date for sentencing is likely to take into account the period that will be taken in the preparation of those reports. Your Ladyship, the request by the prosecution to cancel the bail to which the accused persons were admitted to is not an unusual request. People are admitted to bail on account of presumption of innocence, which has now fallen off. However, Your Ladyship has judicial discretion.
just a minute, so that I do not lose you.
Yes.
You are saying that the preparation of these reports
Will take time.
take time.
Yes. In fact, most likely more than 30 days from experience will be taken in preparation of those reports. And I am saying the request made by the prosecution is reasonable, because people are admitted to bail on the premises that they are presumed innocent. That presumption has fallen off today. Yes, sir. Yes. So, Your Ladyship, I was saying, with the guilty verdict that you've rendered today, that presumption falls off. However, the court still has discretion to extend the bail terms up to the date of sentencing. Your Honor, in respect of the first accused, he was released on bail on the 24th of October, 2018. On 2018, on 24th of October, 2018. That's when he was released on bail. And Your Ladyship, for the last 8 years, he has dutifully attended court whenever required. His passport, including his diplomatic passport, is deposited with the court. I ask Your Ladyship, in view of these circumstances, to consider extending the bail terms to the date of sentencing. That is all, Your Ladyship.
Answer for second, please.
Thank you, my lady. Lady, on behalf of the second accused, we are grateful for the judgment you have rendered. And we take cognizance of the submissions by my learned colleague, the prosecutor. Save as to my lady, since when the second accused was admitted on bail, he has religiously attended court. And even on the single instance when he didn't attend, he provided an explanation which the court didn't give a finding of doubt on the same.
Since the second accused was admitted to bond,
He has been religiously attending court, my lady. And on the single instance he didn't attend because of the reason for illness, evidence of the same was tendered before court, my lady. And to associate myself with the submissions of Marine Senior Counsel Kilikumi, this court has discretion to extend bail until the date of sentencing, my lady. Which we hereby humbly ask the court to consider. That the accused be continued, be allowed to continue enjoying bail until when this court shall render the sentencing. And again, we agree with my learned senior, my lady, that the sentencing report will take a while. We humbly pray, my lady, that's all.
answer for that.
My lady, on behalf of the third accused, I also thank you for the judgment. My lady, to avoid rehashing what my colleagues for the first and second accused persons have said, first, we are ready to take directions as to the sentencing here. And in relation to the application for revocation of the bond and bail terms, on behalf of the third accused, we also pray very humbly that you be pleased to extend the bond terms of the third accused person. My lady, I will adopt mutatis mutandis, the reasons afforded by the learned senior Filekumi and my colleague Mr. Vega. And just as a confirmation, my lady, the third accused person has also religiously attended for the last 8 years. And we'll pray, my lady, that you be pleased to exercise that pressure in his favor. Lastly, my lady, in the intervening period, my lady, we will pray that, and I believe I've seen my lady with a printed copy of the judgment. We will pray that if the same is ready, we will be supplied with a copy of the judgment in the intervening period. Even as we wait for the sentencing. That is all today.
So, Ms. Koya, I don't know whether you have any response.
My lady, I would probably leave it to court. The practice has always been for bail bonds to be cancelled once a judgment for guilty has been provided. So in that aspect, we leave it to the court.
I don't know what is the practice in regarding the time it takes for preparation of these reports, so that that can guide us and determine the return date.
Victims, their geographical area and the accused person's geographical area. So, like, for my bit, it will take maybe a month.
All right. Okay, everything considered, considering the submissions that have been made by the Landed Council on record, the application made by Ms. Kikui for the state, and the responses by the Landed Council, I will take that into account when giving the directions that I'm about to give. And the directions are as follows. The case is adjourned with the following orders: that pre-sentence reports shall be filed by the probation department within the next 21 days. Victim assessment report to be filed within the same period of time. The reports, once filed, shall be shared with all the parties.
We can get a date after the 21 days when the matter can be mentioned to confirm that those directions have been complied with. And pending that mentioned date, the accused persons shall be remanded in custody as their bonds have been cancelled.
Your Ladyship, are we going to have a mention and then we fix a date for the sentencing? Or we are going to fix a date for the sentencing?
I was thinking that we can take a date for the mention first so that we confirm that the documents are filed, so that we can now take a date for the sentencing hearing knowing that we have the documents are ready, so that we don't take a date for sentencing and then it does not take off for lack of the filings. And the reason I gave 21 days is because I thought we could expedite them without having to give the period that was estimated, that the time that they usually take is more than 30 days. Yes.
So, Your Ladyship, can we mention subject to your diary on the 17th of August? I suspect that may be vacation time, and we may need your guidance as to which date you are available. We could probably make the mention virtual, so that we make things easy for you.
I think that's reasonable.
Do we take them the 17th? Virtual mention?
Is it convenient to all?
It is convenient. It's only that Sharon says, will the judge remember the date?
Actually, I'm saying it will be a Monday.
Is it a Monday?
Yes, it's a Monday.
We've had a few issues with Monday. You know that.
But we can make it 18.
We can have the
That's a
Tuesday.
Tuesday. If that's comfortable for the show. But you could give us time indication.
I think 11 is a good time.
Yes.
So at least maybe on Monday we can remind.
But we have taken the 18th.
Yes, so we've taken Tuesday the 18th at 11 o'clock virtually.
Okay. Okay. So those are the orders and directions issued by the court. And the accused persons are hereby formally informed that they have a right of appeal to the Court of Appeal.
My lady, you did not talk about my request for the judgment. I do not know if you have it.
Okay. The judgment is here with me, is typed, but of course I will need to proofread it just to correct a few typos here and there and to polish it up a bit. So I will require your indulgence because it's a very long judgment, as you must have noted. So it will take me a bit of time to finish with the proofreading. But probably by early next week, it should be published. And I will also make an order that you be provided, and a general order that any of the councils be provided with a typed copy, but of course upon payment of the requisite fee.
Even uploading it to the CTS will be there.
Okay.
Do we have time, specific time for the mention?
Yes, I thought we said 11.
11 o'clock.
We've agreed on 11 a.m. So if there is nothing else, then I think it's a good time to adjourn.
Mm-hmm.